Most people believe that when a debt collector calls, they have no choice but to pay. But here's the chilling truth. The Consumer Financial Protection Bureau's 2023 report shows that millions of seniors are being hunted down for debts they don't even legally owe. Every day, older Americans are tricked into handing over rent money, grocery money, even medication money simply because a stranger on the phone counted on their fear. But here's the part that can change everything. Once you understand how the law actually protects you, those intimidating calls lose their power. The moment you know the right words to say, you can shut down almost any collector instantly and keep your hard-earned money safe. That's why this episode matters right now. Because if you don't know these protections, the next phone call or letter could cost you thousands. But if you stay with us, you'll discover 6 specific debts that you may never have to pay, and how to stand firm the very next time someone tries to scare you into opening your wallet. Welcome back to the Smart Senior Podcast. I'm Nancy Miller, and today we're breaking down the real facts about debt collection, so you can protect both your bank account and your peace of mind. The Federal Trade Commission reports that debt collection is one of the most common sources of consumer complaints every year, and adults over 60 are a prime target. If these debts are misunderstood, seniors can lose thousands of dollars unnecessarily, money that should be paying for medications, groceries, or simply enjoying life. And no one is better equipped to guide us through this than retired Detective John Harris. After 4 decades in law enforcement, much of it spent tracking fraud and financial exploitation, he's continued to help families navigate scams and abusive debt practices well into retirement. He has seen firsthand how collectors bend the truth, and how knowledge of the law can flip the power back into your hands.
Thank you, Nancy. It's always a privilege to sit down with you. But let me start with this. If a debt collector calls demanding money, how can we trust their word when half the time they don't even have the legal right to collect?
That is such an important message, and I want everyone listening to think about this for a second. Have you ever received a call or a letter that just didn't sit right with you? Maybe it came from a company you barely remember, or maybe the amount seemed to change every time. If that's happened, I'd love for you to share your story in the comments. You never know who might be helped by hearing it.
Fear is the biggest tool collectors use, but knowledge is the best defense. That's why today we're going to walk through 6 specific types of debt that seniors often think they have to pay, but in many cases do not. From old utility bills to expired payday loans, even tax issues, we'll cover it all. By the end, you'll know how to tell the difference between a real obligation and an empty threat.
Let's begin with something almost every senior can relate to. Utilities. The lights, the water, the gas. At some point, everyone has dealt with a bill that came after moving, cancelling service, or switching companies. And for a lot of people listening, those little envelopes or phone calls still cause worry. John, let's start right there. What really happens when a utility account is closed, but the bills keep following you?
This is a perfect place to start, Nancy, because it is one of the most common sources of unnecessary stress for older adults. Here's the truth that most people don't realize. Once a utility company disconnects service and sends out a final bill, that account is considered closed. That's the end of the relationship. You may still see a balance due on that final statement, but once the service is cut off, the company has already made a business decision. They know the likelihood of collecting a small balance is very low, and the reality is they rarely go to court to chase it. It costs them more to pursue the debt than the amount they are trying to recover.
So, if someone has an old light bill from 2 or 3 years ago for $70 or $80, they may not really be in danger of being sued.
That's exactly right. Unless the balance is very large, these companies usually write it off and move on. But here is where seniors run into trouble. Those old accounts often get sold to third-party collectors. A collection agency might buy a bundle of old utility debts for pennies on the dollar. And once they own it, they begin calling and sending letters, hoping people will pay simply out of fear or confusion.
That explains why I've heard from listeners who say they kept paying the same old bill, because letters just kept coming. They thought ignoring it would make things worse.
And that's exactly what the collectors are counting on. They know that for many seniors, the fear of being taken to court or having their credit destroyed is enough to make them send a payment, even if legally the company has no intention of pursuing it. Collectors use pressure tactics because they work. They are not lying when they say you had an account, but they are stretching the truth about your obligation.
It makes me think of a neighbor who moved out of state years ago. She told me she still gets a letter now and then about an old water bill she swears she paid. She always worries that if she ignores it, someone will show up at her door. That fear weighs on her more than the bill itself.
That's very common, Nancy. And here's the important teaching point. When you get a notice like that, the first step is to pause. Don't respond right away. Don't send money just to make it go away. Instead, ask the collector to verify the debt in writing. By law, they are required to provide documentation showing the amount owed and proof that they are legally authorized to collect it. If they cannot provide that, you have no obligation to pay.
That is such an empowering reminder. You don't have to react in panic. You can slow down and ask for proof.
Exactly. And another thing to remember is that essential services like gas and electric are almost never shut off retroactively for an old address. If you are living at a new home with your bills current, you don't have to fear that someone will suddenly turn off your lights over a past account. That's not how it works. Utility service is tied to the address, not to your future.
I think hearing that will bring a lot of peace to people listening, because the thought of losing something as basic as electricity can be terrifying, and collectors know that.
They do, and they use it. But I want seniors to understand that when a service is being disconnected and a final bill issued, that account is a closed chapter. Yes, there may be some leftover balance. Yes, letters may come. But in most cases, it is not legally enforceable in a way that can threaten your home or your independence. And if the amount is small, courts will not waste their time with it.
So the key lesson here is to stand firm. Don't let the fear of a letter or a call push you into paying something that is not truly required.
That's right. The more you know, the less power those collectors have.
Before we move on, I want to stop and ask everyone listening something. Have you ever had a utility bill chase you after you moved or shut off a service? Did you pay it, or did you challenge it? Share that in the comments, because your experience could really help someone else realize they are not alone in this.
That is so important, Nancy. Seniors need to hear from each other. It builds confidence when you know others have faced the same thing and come through it just fine. And remember this, when you are contacted about an old utility bill, you are not powerless. You have the right to question it, the right to demand proof, and the right to protect your income. Knowledge and patience are your best defenses.
That's such a strong foundation for where we're headed today. And I know what's coming next is going to be just as eye-opening, because utility bills are only one piece of the puzzle. The next type of debt is one that breaks my heart, because so many seniors tell me it makes them feel like they are drowning. We're going to talk about medical debt, and John, I know you'll help us see through the confusion of collectors calling from every direction. John, I want to shift us to something that weighs heavily on so many seniors, and that is medical debt. It is the number one concern I hear about when I talk to people in my community. They tell me they feel like they are drowning in bills, like no matter how much they pay, the balance never gets smaller. I think it breaks hearts and spirits more than anything else, because it is connected to health, something people never choose to struggle with.
You are exactly right, Nancy. Medical debt is one of the most confusing and intimidating forms of debt that seniors face. The healthcare system in this country is complicated enough, and when you add in the financial side of it, it becomes overwhelming. Here is where it gets especially tricky. The same medical bill can be sold and resold multiple times. Imagine you had a hospital stay that left you with a $2,000 balance. The hospital may decide to sell that bill to a collection agency. Then, if that agency cannot collect, they may turn around and sell it again. Before long, 3 different collectors may be contacting you about the same exact bill.
And that must be terrifying, John. I can imagine someone at home getting 3 phone calls in a week, each one from a different agency, each one demanding payment. If you are sitting there with limited income and shaky health, It would be easy to think you owe all of them.
That is exactly the fear these companies rely on. But here is the truth. You do not owe all three. In fact, sometimes you may not owe any of them if they cannot provide the proper proof. Only one collector at a time can legally hold the rights to collect a debt, and they must be able to show documentation proving they own it. Without that documentation, their threats are just noise. The problem is most people do not know to ask. They take the calls at face value and the stress multiplies.
So what should someone listening do if they are getting multiple calls about the same bill? What is the first step?
The very first step is to slow down and request debt validation. Every collector is required by law to provide a written notice explaining the amount owed and evidence that they have the right to collect it. If you receive a call, do not agree to anything over the phone. Instead, say you want a validation letter sent to you in writing. Once you have that, you can compare it to your own records. If they cannot or will not send it, that is a huge red flag that they do not actually have legal standing.
That makes so much sense. Take it off the phone, slow down, and demand proof. Because when you are on the phone, you feel pressured. When you have it in writing, you can look at it calmly, ask questions, and get help if you need it.
Exactly. And another important point is that paying one collector does not automatically protect you from another. If you pay someone who does not have the proper documentation, that does not erase the debt. The real holder of the debt could still come after you. That is why proof is so critical. You should never hand over money without knowing for certain that the agency is the rightful owner of the account.
That part right there is what I think will shock a lot of people. Because many seniors think, if I just pay something, at least it will be behind me. But what you are saying is if you pay the wrong person, it does not solve the problem. It can actually make it worse.
Yes, and unfortunately I have seen that happen many times. Seniors drain savings or skip essentials to pay a collector only to learn later that it did not count. That is devastating. And that is why I want to stress again, the law gives you the right to demand validation. Exercise that right. It is there for your protection.
I want to pause here and ask our listeners something, because I know this will hit home. Have you ever been contacted by more than one agency about the same medical bill? What did you do in that situation? Did you pay, ignore, or question it? Share your story in the comments, because your experience could give strength to someone else who is feeling the same pressure right now.
And let me add one more piece of advice. If you are unsure, do not hesitate to involve a trusted advocate. That could be a lawyer, a financial counselor, or even a family member who understands paperwork. Having someone else look over the documents can give you confidence. Scammers and aggressive collectors thrive on isolation. They want you to feel like you have no one to turn to. But the moment you bring another set of eyes into the conversation, their power weakens.
I love that, John. Because sometimes the hardest part is not the bill itself, but the feeling of being alone and not knowing what is real. And when you feel alone, it is easier to be pressured.
That is right, Nancy, and I want to reassure everyone listening. Medical debt is complicated, but you are not powerless. You have rights. You can challenge collectors. You can demand proof. And you can refuse to pay when the documentation is not there. Do not let fear or confusion take away your hard-earned money.
This is such an important conversation. Because when you are dealing with health challenges and fixed income, the last thing you need is the added stress of phantom bills. And John, what you have explained here is so freeing. It means people can stop feeling like they are drowning and instead start feeling like they can take a deep breath again.
That is the goal. Empowerment through knowledge. Once you understand how the system works, you stop being a victim of it, and that peace of mind is priceless.
John, I want to turn now to something that is very personal for a lot of families, and that is cosigning or sharing accounts with adult children. So many parents step in to help their kids by cosigning for a car loan, a credit card, or even a small personal loan. At the time, it feels like the right thing to do. You want to help your child build credit. You want them to get that vehicle for work or school, and you want to support them. But years later, those decisions sometimes come back in the form of collection calls and letters. Seniors tell me they feel blindsided when a debt they thought was long forgotten suddenly lands in their lap.
Yes, Nancy, this is one of the most emotional areas of debt because it mixes family loyalty with financial responsibility. Collectors know that if they can stir up fear, they can pressure a parent into paying. They will call and say, "You signed on this loan, you are responsible for every penny, and if you do not pay, terrible things will happen." The truth is, though, it depends entirely on the paperwork. Not all cosigners are equally responsible. Some contracts clearly outline primary versus secondary responsibility. In other cases, the language is vague and collectors take advantage of that vagueness to exaggerate liability.
That has to be so confusing for people, because once you hear the words "you are on the hook," it feels final. People believe they are about to lose their savings or have their social security taken away.
And that is where I want to stop and reassure everyone. Social Security is protected in most cases. Collectors know this, but they still use it as a threat. They might imply your monthly benefit will be seized, but legally that is very difficult and rarely happens, especially for consumer debt like credit cards or car loans. What they are doing is creating fear to make you hand over money quickly.
It breaks my heart to think about parents who stepped up to help their kids years ago and now feel punished for that kindness. They think helping their child could cost them their independence in retirement.
It is heartbreaking and it is unnecessary when you understand the law. Here is the practical advice I give. If you are contacted about a joint debt, the first thing you should do is request the contract. You want to see the original paperwork that shows who signed, what responsibilities were agreed to, and how liability is divided. If a collector cannot provide that paperwork, then they do not have the legal standing to collect from you. Too many seniors never ask to see it because they feel intimidated. But that document is the key to knowing where you actually stand.
That is such valuable advice. Slow down, ask for the contract, and do not just take their word for it, because their words are designed to scare you, not necessarily to tell the truth.
Exactly. And another important point is that paying even a small amount on a debt can sometimes reset the clock on the statute of limitations. That means if the debt was close to expiring, making a payment could actually revive it. That is why you must be certain before you hand over money. Get advice, get the paperwork, and do not act in panic.
I want to pause here and ask our listeners something directly. Have you ever cosigned for a child or grandchild, only to have the debt come back years later? What did you do when the calls or letters started coming? Share your story in the comments. I think hearing from one another is so powerful because it reminds us that these situations are more common than we think and that there are ways to handle them without fear.
That is a great question, Nancy, and I hope people do share. I will add one more thing. Helping family is natural, but it should never mean sacrificing your own security. If you are considering cosigning now, think carefully. Ask yourself, can I afford to pay this loan if my child cannot? If the answer is no, then cosigning may not be a safe choice. If you already cosigned years ago and are now being contacted, remember your rights. Collectors cannot simply take your Social Security, they must prove their case. And without that contract, they have nothing.
That is such a protective mindset, John. You are not saying never help your kids, but you are saying protect yourself first. Make sure you understand the risks, and if it comes back later, do not give in to fear.
That is exactly it. I want seniors to know that the law is often on their side. Collectors thrive when people feel ashamed or guilty about helping their children. They want you to believe that you are trapped. But you are not trapped. You have the right to question, to demand proof, and to refuse payment when the obligation is exaggerated or misrepresented.
This is such an eye-opener. It takes something that feels heavy and frightening and gives it clarity. And before we move on, I want to say this. Only about 10% of our listeners are subscribed to the channel right now. If this conversation is helping you, if it is giving you peace of mind, please take a second to hit that subscribe button. It is free, and it allows us to keep bringing you important information that protects you and the people you love.
Well said, Nancy. Staying informed is the best defense. And this issue of joint accounts is just one piece of the puzzle. Next, we need to talk about another trap that so many seniors fall into during moments of financial strain: payday loans and cash advances. These are marketed as quick fixes, but what most people do not realize is that many of them expire and cannot legally be collected after a certain time. That is going to be eye-opening for a lot of folks.
Only about 10% of our listeners are subscribed. If you're finding this helpful, take a second to subscribe right now. It helps us keep bringing you these conversations, and more importantly, it helps keep you safe from scams. John, let's talk about something that comes up often in my conversations with seniors: payday loans and cash advances. These are the kinds of loans people usually turn to when they feel desperate, when a car breaks down, when a medical bill comes due, or when groceries and prescriptions have to be bought before the next check arrives. Seniors on fixed incomes sometimes feel they have no choice but to take out a small, quick loan. But years later, those loans seem to come back around, often with collectors calling out of the blue. Can you help us understand what is really going on?
You are right, Nancy. Payday loans are a lifeline for some in the moment, but they often turn into a trap. The first thing people need to understand is that every state has what is called a statute of limitations on debt collection. For payday loans and cash advances, that time frame is usually short compared to other debts. In some states it may be 3 years, in others it may be 6. What that means is, once that time has passed, collectors cannot legally sue you to recover the money. The debt still exists in theory, but it is what we call time-barred. It is no longer enforceable in court.
That is such an important distinction, because when someone gets a phone call 10 years later about a payday loan they barely remember, their first reaction is fear. They think, I must pay this or I will be taken to court. But you are saying the law does not allow that once the time has passed.
That is exactly correct. After the statute of limitations expires, the debt is legally dead. Collectors may still try to collect, and some will use harsh or intimidating tactics. They will call, threaten, and demand immediate payment, counting on the fact that most seniors do not know the debt is unenforceable. But no matter how loud they get, the truth is they cannot drag you into court for it.
I can imagine that knowledge alone could ease a lot of worry. But here is a question I know many people are thinking. What happens if someone, out of fear, makes a small payment on that old loan? Does that change anything?
That is a very good question, Nancy, and the answer is yes, it can. In many states, making even a small payment on a time-barred debt resets the statute of limitations. That means if the debt was 10 years old and unenforceable, sending in $20 might make it legally collectible again. Collectors know this, which is why they sometimes push for just a token payment. They may say, pay $20 or $50 to show good faith. But what they are really doing is reviving a debt that should have stayed buried. That is why it is critical not to make payments on old payday loans without first confirming whether the debt is still active under state law.
That is almost sneaky, John. It sounds like they use psychology to get people to act against their own best interest.
It is sneaky, and unfortunately it is effective. They rely on fear and urgency. That is why my advice to anyone who receives a call about an old payday loan is to pause, ask when the debt originated, ask for documentation, and most importantly, check your state's statute of limitations. If it has passed, you have the legal right to say no. You do not owe them anything.
I want to stop here and ask everyone listening to think about this. Have you ever been contacted about a loan you thought was long behind you? Maybe it was from years ago. Maybe you barely remembered signing it. What did you do? Did you pay it, ignore it, or question it? Share your story in the comments, because I guarantee there are others listening right now who need to know they are not alone in this.
That is so important. Nancy, these situations can make people feel embarrassed or isolated. They think, I must be the only one who fell for this. But the truth is, thousands of seniors have faced the exact same calls. Talking about it removes the shame and gives people the courage to stand their ground.
Another question that comes up is about threats. I have heard from people who say collectors threaten to send the sheriff to their house, or even have them arrested if they did not pay. That kind of talk can be terrifying.
It can, and it is absolutely unlawful. Debt is a civil matter, not a criminal one. You cannot be arrested for failing to pay a payday loan. Any collector who makes that threat is breaking the law. What you should do in that case is document everything. Write down the time, the number they called from, and what was said. Then report it to your state attorney general's office or the Consumer Financial Protection Bureau. Seniors need to know that they have not only the right to say no, but also the right to report abusive practices.
That shifts the balance of power, doesn't it? Instead of feeling like the collector has all the control, the senior can turn the tables and hold them accountable.
Exactly. The more you know, the less control they have. Knowledge is the shield that keeps you safe. If a payday loan is expired, it is expired. No phone call can change that fact.
That is such a hopeful message. What I hear you saying is, the next time someone listening gets a call about a payday loan from years ago, they should not panic. They should take a breath, check the law in their state, and remember that time is often on their side.
That is right, Nancy. Debt collectors want you to believe you are powerless. But in many cases, the law says you are free.
This is exactly why we are doing this series, John, because every time we shine a light on these tactics, we take away a little bit of fear and replace it with confidence. And speaking of confidence, I know what we are covering next is going to hit close to home for a lot of people. We are going to talk about timeshares, which so many seniors regret buying. And John, I know you are going to explain how those maintenance fees people keep hearing about may not always be enforceable. John, let's move into something that I hear a lot of regret about when talking with seniors, and that is timeshares. For many people, it started with a dream. They pictured vacations every year, family gatherings, a chance to relax somewhere sunny. But over time, what began as an exciting purchase turned into a burden. The maintenance fees kept climbing, the schedules never lined up, and eventually many seniors just stopped using them. Later, they tell me those fees keep haunting them, even when they thought the timeshare was behind them.
You are absolutely right, Nancy. Timeshares are one of the most common financial regrets that seniors face. What happens is this. A person decides they can no longer afford or no longer want to keep the timeshare, so they stop paying the fees. The timeshare company will usually take back the property through a process called foreclosure or surrender. Once that process is legally completed, the timeshare is no longer in the person's name. But collectors often keep calling anyway, claiming thousands of dollars in so-called maintenance or special assessment fees. The important truth is, if the timeshare has been foreclosed or surrendered properly, you do not owe those ongoing fees anymore.
That is such an important point. Because people assume if the phone rings and someone says you still owe, then it must be true. And because timeshares often involve contracts and legal documents, the whole situation feels intimidating. Seniors think, maybe I just do not understand, and maybe I had better pay to avoid trouble.
And that is exactly the fear the collectors rely on. But the key question to ask is simple. Is the timeshare still in my name? If the answer is no, then you are not responsible for fees after the date of foreclosure or surrender. Collectors may try to convince you otherwise, but they cannot enforce those payments once ownership has been removed. This is why it is critical for seniors to check the paperwork and confirm whether the timeshare is still legally attached to them.
Imagine that is easier said than done sometimes, though, because not everyone has kept all their papers from 10 years ago, and some companies are not exactly quick to provide clear answers. What should someone do if they are unsure whether the timeshare is still in their name?
That is a good question. If you do not have your paperwork, you can check with the county recorder's office where the timeshare property is located. They can tell you who currently holds the title. If it is not you, then you have the proof you need. Another step is to request written verification from the timeshare company itself. By law, collectors must also provide documentation if they claim you owe. Do not accept phone threats. Insist on written proof. If they cannot give it, you have strong evidence that you do not owe a thing.
This is starting to sound very similar to what we talked about earlier with other debts. The pattern seems to be, do not panic, ask for proof, and never just pay because someone calls.
Exactly, Nancy. The rule of thumb is to take your time, get it in writing, and verify ownership. The sad reality is that many seniors pay thousands of dollars for fees on timeshares they no longer even own. Collectors take advantage of nostalgia, guilt, and confusion. But the law is clear. If you no longer own the timeshare, the company cannot keep billing you for it.
I think that reminder will be such a relief for people listening, because I know some who worry constantly about these calls, and they feel ashamed for ever having bought the timeshare in the first place. It feels like an expensive mistake that keeps costing them over and over.
And I want to speak directly to that shame. Buying a timeshare is not a mistake that defines you. It was a decision based on the information and dreams you had at the time. Many people made the same choice. The mistake would be allowing collectors to use that regret to pressure you now. Instead of feeling guilty, focus on protecting yourself going forward. Remember, you are not obligated to pay fees on something you no longer own.
That is such a freeing thought. And before we move on, I want to pause and ask everyone listening something. Have you ever owned a timeshare that you gave up or lost to foreclosure? Did the fees keep chasing you after it was gone? What happened when the calls or letters came? Share your story in the comments. I promise, what you share could be the lifeline someone else needs right now to stop living in fear of those collectors.
That is a wonderful invitation, Nancy. Stories build strength, and I know many people will find comfort in hearing they are not alone.
John, I can already feel how much lighter this conversation will make our audience feel. The idea that a timeshare no longer in your name cannot keep draining your money is powerful. But I also know what we are about to cover next may be the most intimidating topic of all. Because if there is one organization seniors fear, it is the IRS, and that is where I want us to go next. We are going to talk about old tax debt and what it means when the IRS decides you are uncollectible.
Yes, Nancy, taxes strike fear into the hearts of many seniors, but there is a surprising truth that will bring peace of mind. I look forward to explaining how even the IRS recognizes when someone simply cannot pay and how that status can protect your income.
John, I think this may be the most intimidating topic we have covered yet. Whenever I talk with seniors about debt, nothing sparks more fear than the IRS. People will tell me they can handle a collection agency, they can even ignore a utility bill, but when it comes to tax debt, they feel helpless. Some have told me they lie awake at night worrying that the government will take everything they own. Is that fear accurate, or is there something they need to know that could ease their minds?
Nancy, you are right. The IRS is the most feared collector in the country. And it is true, they have powers that private collectors do not. They can place liens, they can garnish wages, and they can reach into bank accounts. That is why the fear feels so real. But here is what too few people understand. The IRS also recognizes when someone simply cannot pay, and in those cases, they will often mark a taxpayer as currently not collectible. That status means the IRS agrees to freeze collection efforts. They stop garnishments, they stop sending threatening letters, and they leave the person's limited income alone.
That sounds almost unbelievable, John. Most people think once the IRS decides you owe, there is no way out. But you are saying the government itself sometimes chooses to back off.
Yes, and it surprises almost everyone when they first hear it. The IRS does not want to waste resources trying to collect from someone who is living on Social Security or barely covering their basic needs. When they see that taking money would mean someone cannot afford food, housing, or medical care, they will often grant this status. It does not erase the debt completely, but it does give seniors breathing room and peace of mind.
I can imagine the relief someone must feel, hearing this for the first time. After years of hiding from letters and phone calls, to realize the IRS itself might protect them from further collection. How does a person actually get placed into this currently not collectible category?
The process begins with a collection information statement. It is essentially a form where you report your income, assets, and expenses. The IRS reviews it to see whether collecting would leave you unable to meet basic living standards. If the numbers show you cannot reasonably pay, they grant the status. From that point forward, collection is suspended. It usually lasts at least a year, sometimes longer, and it can be renewed if the situation does not improve.
That paperwork must feel overwhelming, especially for someone who is already nervous about dealing with the IRS. What do you recommend seniors do if they feel too intimidated to try?
That is a fair concern, Nancy. The forms can look complicated, but help is available. Many communities have volunteer tax programs specifically for seniors. There is also the Taxpayer Advocate Service, which is part of the IRS but operates independently to protect taxpayer rights. My advice is not to try to go through it alone if you feel unsure. Ask for help, bring a trusted family member, or reach out to one of those organizations. Facing it with support removes much of the fear.
That feels like such an important shift. Instead of hiding from the mail and dreading every phone call, you can step into the light, ask for help, and take action that brings peace. Because the worst fear is often the unknown.
Exactly, Nancy. Fear grows when we avoid the issue. Once you understand that the IRS has programs and protections, the fear begins to shrink. And I want to emphasize another point. Even if someone does not qualify for currently not collectible status, there are still other options like installment agreements or an offer in compromise which can settle tax debt for less than the full amount. The key message is that you always have options, and the IRS does not want to see seniors destitute.
That is reassuring, John. And I think our listeners will appreciate knowing that the law is not as cold as they feared. There is room for compassion, even from an agency as intimidating as the IRS.
Yes, Nancy, the IRS is serious, but they are not heartless. They recognize when someone cannot pay, and they have mechanisms in place to provide relief. The challenge is that too many seniors do not know those mechanisms exist. They assume the debt will haunt them forever when in fact it can be paused and controlled.
Before we close this section, I want to ask our listeners something. Have you or someone you know ever dealt with old tax debt? Did you discover a program that gave you relief? Or are you still living in fear of those letters? Share your story in the comments, because what you write may give courage to someone else who feels like the IRS is closing in on them.
That is such a powerful invitation, Nancy. When seniors hear from others who have faced the IRS and found a path forward, it gives them strength. I want everyone to know this. You are not powerless. You have rights. And even the IRS recognizes limits. If you are living on a fixed income, there is a good chance you can qualify for relief. Do not let fear steal your peace.
That is exactly why this conversation matters so much, John. You have taken something that feels terrifying and shown us the truth. Seniors are not without protection, even against the IRS. I'd love to hear from you. Have you or someone you know ever been pressured to pay one of these debts? What happened? Your story could help another senior out there feel less alone. John, what we have done today is shed light on 6 different kinds of debt that so many seniors lose sleep over. From utility bills that linger after service is cut off, to medical debts that get sold over and over, to co-signing for children, payday loans, timeshare fees, and even tax obligations. Each one carried a heavy weight of fear. But you showed us that in many cases the law offers protection. The pattern is clear. Just because someone says you owe does not always mean you truly do.
That is the most important lesson, Nancy. Awareness is protection. Scammers and aggressive collectors depend on silence, fear, and quick reactions. But the moment you slow down, ask for proof, and understand your rights, their power shrinks. Seniors are not powerless. They are not helpless. With knowledge and a calm approach, they can protect their money, their independence, and their peace of mind.
And I want to leave everyone listening with a simple step. If you get a letter or call this week about money owed, do not react immediately. Pause and share it with someone you trust. That could be a lawyer, a family member, or a local advocate. You do not have to face it alone. and you should never pay until you are certain it is real. And I would love to hear your stories. Has anyone tried to collect from you on a debt that felt suspicious or unfair? Share it in the comments. We read every single one, and your story could be the encouragement another senior needs.
That is exactly the kind of community we want to build. A place where seniors know they are not alone, where they share knowledge and protect each other. When you spot the signs, you stop the scam. And together, by speaking up and staying informed, we can make it harder for these schemes to succeed.